Punitive damages are how the plaintiff's action or inaction can affect a damages award. So the defendant's conduct is deemed particularly outrageous or careless. Probably some of the real goal of these kinds of damages is to punish the defendant for his conduct or act as a deterrent. And two of the most common factors that you want to document, and it may even hurt your case, but you have to document it for trust issues. And the two most common ones you should always be paying attention to was alcohol involved, or medication that may have altered their senses, and were they wearing a seatbelt? Were their senses altered through alcohol or medication, and were they wearing a seatbelt? Those are the two most common. And so it will hurt their case if they weren't wearing a seatbelt or if there was alcohol involved. But it's better that you have it documented and bring it up than the other attorney bring it up and you not being aware of it, because then it hurts your case when you don't do that. It actually will hurt everything else you're saying because of your authority. So punitive damage, or how the plaintiff's action or inaction can affect the damages. What was the injured person's role in the act causing the accident? And again, their inaction after being injured. And this is important too. What did the person do or not do? So if the person doesn't seek care, that can hurt the case. If they don't seek care and to be evaluated, it can diminish the amount of, in other words, they're showing neglect for themselves, which leads to a permanent injury. And if you think about it, that makes sense. And so that will hurt their case. But you need to document and be aware of these things. And then chiropractic supports the probability of the cause and effect relationship. Now, this is very important. You have to show, remember in the 4 pillars of personal injury, number one is you have to, with your consultation and the thoroughness of your consultation, you want to be able to say with high certainty or probability that this accident caused this injury. You need to and want to be able to say it. Now, if it didn't do it, you can't say it. But you have to say that. You have to literally say it. You cannot insinuate it. You cannot dance around it. You cannot hope that they think what you meant. You have to flat out say it in your narrative report or in a deposition. It's the cause and effect relationship. So, and that helps to minimize the punitive damages. So once again, you're helping with this claim. And comparative negligence, if you're at fault or even partially for the accident, these are going to be factors. And again, that's the probability of the cause and effect relationship. You're looking at the mechanism of the injury of the accident relative to the injured anatomy. And that's what, in that consultation, that's what's so important, is establishing that cause and effect relationship. Remember, if the insurance attorney can show that the more they can show, and this is one of the things the insurance company always tries to do to decrease financial liability, is to find these things and put some degree of blame on the injured party, and that helps mitigate the responsibility or the damages. So contributory negligence, you're deemed partially to blame for the accident after the accident, failure to mitigate damage, failing to get necessary medical treatment, making their injuries much worse. So that's a common one. Once again, chiropractic, a good, thorough consultation with the mechanism of injury relative to the injured anatomy will help support and deny these negligent issues. That's what they'll do. And so this is how chiropractors support personal injury attorneys in compensatory and punitive damage claims.